Okay, the court will call the case of State versus Co. 122797. Would the parties state their appearances, please?
May it please the court, Dr. Coe appears through counsel Chris Joseph.
May it please the court, the appellee State of Kansas appears by Assistant Solicitor General Stephen Obermeyer.
Thank you. Welcome to this morning's session. I'm Chief Judge Karen Arlberger. I'll be presiding today over the panel. To your left is Judge Gordon Atchison. I'm a senior member on our panel today. And to my right is Judge J.C. Hurst, the newest member of our court. So you've got a wide breadth of judicial experience here. As you all are common arguers before a court, so you know that we know the facts of your case, and that you'll each have 15 minutes to argue, and that Mr. Joseph, I'll need to know if you want to reserve any time.
I'd like to reserve 3 minutes. I'll
Okay.
shoot for that.
Okay. Well, you'll also find out that I'm probably the worst timekeeper on the court. So I get wrapped up and I forget to look and see what the time is. So with that, if the two of you don't have any questions, we can go ahead and get started. Mr. Joseph.
Thank you, Judge. As the court is aware, there's two reasons to reverse the conviction of Dr. Coe, and I'm going to take them in order of the briefing. The first issue being that the crime of conviction has an element of consent, which was not met and which was not provided to the jury in instructions. Taking a high-level view, Article 55, which sets out sex crimes, has two categories of crimes. By and large, it's either a crime where the victim does not consent, and then there's two crimes where a victim does consent or voluntarily engages in the sexual conduct. The offense level for those where the defendant or the victim, does not consent generally is much more severe, and that's by design. This is an odd set of facts, however, in that the severity level for a touch is actually a misdemeanor battery. The state then had to choose between proceeding on misdemeanor sexual battery, which is touching a victim 16 years of age or more who does not consent with the intent to arouse the sexual desires of the defendant. The state was not apparently satisfied proceeding on the crime that fit, where there is no consent. And they decided to take a novel approach and take from that bucket of crimes where the victim consents or voluntarily engages in sexual conduct in order to get a felony. And the state proceeded on that grounds, despite the word consent being in the judicial conduct's model instruction, and they took a risk. They took a risk to get up to that felony level. They have consistently made good policy arguments at the district court level and before this court about why consent should not be an element. And the district court itself ruled that consent should not be an element. I think actually the district court's ruling is very revealing. Page 19 of the state's brief, there's a block quote that goes back to the court's ruling during jury instructions. The court explained, this district court explained, it would not have made sense for the legislature to intend that the crime required be consensual when you're dealing with an inmate. There should not be a requirement of consent. That's a policy issue. That's an issue that goes to the legislature. And frankly, when you think about it, it would be silly to say consent only applies to one of the three listed types of sexual contact. That would make no sense. And in fact, both the district judge, the prosecutor, and the state on appeal are making lots and lots of good policy arguments that need to be presented to the legislature, but this is not the forum. Dr. Coe went to trial when consent was an element. I mean, just frankly was an element, and we don't change the law retroactively. It's an element.
Mr. Joseph, is it actually sensible to impute to the legislature the intent to make a level 5 felony out of consensual contact and to punish non-consensual or objected to contact is like a or B misdemeanor? I mean, is that your argument is the legislature acted reasonably, and that's not an unreasonable or absurd result? It seems kind of weird to me.
Yeah, no, look, I agree with you. I mean, I think it is weird, but there are a lot of times I think what the legislature does is weird. I used to, and it's still on the books, I checked, electronic solicitation of a minor versus indecent solicitation, in-person solicitation. And I've made this argument for departures and variance. If you solicit a child electronically, it's a level 1 or a level 3. Go to prison for a long time. But if you do it in person indecently, it used to be a level 8. Now it's a 5 or 6. I mean, that's weird, right? I mean, I don't understand the policy behind it, but that doesn't matter. We don't substitute our views of what the law should be and how severe a crime should be punished with the legislatures. We apply the law as it's written. We may think the law is wrong or silly, but we don't change it.
Well, I mean, does this tumble over into the area of absurd? I mean, we are not supposed to interpret the law to reach an absurd result. And I'm not sure I see the distinction between an A or B misdemeanor for an objected to touching and a level 5 felony for a consented to touching as something other than, I mean, that seems to me to be at least in the general ballpark of absurd. Maybe out in the cheap seats someplace, but I don't know. I mean, explain to me. I'm not getting why that's.
First of all, it's a policy disagreement.
Sensible.
I mean, I really genuinely think that's a policy disagreement, and maybe the legislature ought to reconsider it. I know there's a bill out there that may address that. That's a policy disagreement as to whether or not it should be a different severity level. But I will tell you what I think is absurd and what that is meant. I mean, when you look at absurd results, or what you're looking at is the language, and what would be truly an absurd result is to look at it and say, okay, it has to be consensual for sexual intercourse, but not the other two categories. I mean, that would be crazy, right? It's an element. So if an inmate and a prison guard engage in lewd, fondling and touching, or even sodomy, it doesn't have to be consensual. You can prosecute on that. But if they go further to sexual intercourse, it has to be consensual. That judge, I think it would be what is truly meant by an absurd result. That would be silly.
Well, but it isn't the situation now an unconsented act of sexual intercourse is rape, which is actually a more severe crime than that. I mean, that's the sensible rejoinder to your argument that it's absurd simply to indicate that sexual intercourse is the only one that has a consensual element to it in this statute.
Well, I mean, that's true across the board. I mean, lewd, fondling, and touching, when it involves a minor or otherwise lacks consent, is more severe. Sodomy, when it involves a minor, it's more severe. I mean, when there is no consent, it's generally always more severe. Just because we have a disagreement with the legislature's lower severity, that's not what is meant by absurd result.
If we were to read this statute so that consent is only required for sexual intercourse, but it's not required for sodomy. So I think this is interesting because in order to read it this way, there's quite a big difference between touching, lewd touching, and sodomy in the unconsented realm, right? So the punishment, if we were to read it as consent's only required for sexual intercourse, but it is not required for lewd touching or sodomy, we would be putting unconsented sodomy in the same realm as unconsented leg touching.
Correct. I mean, the state's interpretation is to break it. So the word lewd breaks that, and it only modifies sexual intercourse, which I think that is an absurd result. And frankly, to the extent there's ambiguity, legislative history, and I think our reply brief really went through it, it's really clear. And to the extent that doesn't resolve it, you have to give, strict reading and give deference to the defense on that, construed against the drafter. So, I mean, this is really clear if you go through the legislative history. I don't think there's ambiguity. I think the plain language is there. But if you go past plain language, I don't see how legislative history gets you anywhere other than it being an element. It was meant to be an element. Even subsection C, by the way, subsection C is not how you change elements of a crime. If you're going to change elements of crime, you go up to subsection A, you strike the word consent, or you break it out into 3 subsections. And even subsection C, as you noted in our review of the legislative history, it was introduced as, hey, we're making a modification to the consensual sexual relations statute. So, I mean, the legislature quite clearly intended this. There's no doubt there. And if we're going to go back and disagree and say it's absurd what they intended to do, that's not what that provision of statutory construction is meant. You do plain language, then you turn to legislative history, and then to the extent that there's still ambiguity, you got to construe it against the drafter and the state. I'm not clear on where I am on time, but I'm going to switch over, if I may, with the court's permission.
You still have a couple minutes.
Okay, switching over to the TA case. So there has to be the touch itself, right? The act itself, touching someone on the thigh just above the knee, the touch itself has to be lewd. And
Has to
in
be
this
what?
case,
I'm sorry.
Lewd.
Lewd. Okay. I'm sorry, I didn't hear you. Go ahead.
the touch itself must be lewd. We don't look at the subjective intent. The 2 elements cannot be collapsed into one. Now, the state points to circumstances, and lots of circumstances. Those circumstances, when you think about it, inform of the defendant's intent. They don't change the nature of the act, right? What could make it? Could there be a scenario where maybe the touch on a knee could be lewd itself? Well, look to the Rule 609 letter that the state provided. When there's more, there's, sitting on the lap and rubbing the leg.
Do you agree though that we would look at the knee touch in the context of the circumstances and not just every knee touch is the same?
So you have to disregard the circumstances that inform intent, right?
Right,
So,
but we can look at the other circumstances around the knee touch.
right. So the circumstances around it is they are sitting next to each other, working closely together on these dentures. And if you look at the record, they're talking about how they're shoulder to shoulder, working in close proximity. There's instruction, there's guidance.
What about her inmate status? The relationship.
As a circumstance?
Right.
Well, the court says to look at the touch itself. And so I don't know. I don't know that would qualify. I mean, I think that's getting out a bit far beyond the physical circumstances. To me, when the court is talking about, you look at the act itself, you look at the physical circumstances surrounding the act itself. And the physical circumstances, they're shoulder to shoulder, working together, instructing. There's times where people will put the arm around you or touch your shoulders that are kind of awkward and creepy, but they're not lewd. This is sitting next to each other, instructing, touching a knee, awkward, but not itself lewd. Now, the state's circumstances say maybe he intended it to be sexual because of all these other things, but TA instructs and controls that that's not what we look at. We don't try to figure out what's going on in his mind, because what's going on in his mind may be bad, but you look at the physical circumstances, the physical activity going on. That's how I understand TA.
Is there evidence in the trial record as to how the victim was dressed when her leg was touched?
I can't
Was
recall.
it fair?
I can't recall offhand, but I mean, they were. I think the jury saw them. I mean, they're wearing the inmate garments, full pants for.
Well, I'm making an assumption about how female inmates are dressed. But I guess I'm asking whether there was actual evidence in the record as to whether she testified as to how she was dressed, or somebody testified, or there were photographs or something.
There certainly were photographs of the room. The inmates appeared and testified dressed as they, I believe, ordinarily would, which is full length pants, full clothes. They were, so I think the jury had an opportunity to see that. I don't recall off the top of my head if they specifically said they always wear what they're required to wear, which is the full length pants. And, there was no bare skin touch described. And I'm
Okay, well, that's what I'm getting. I mean, she didn't describe a skin to skin contact with the leg. I mean, obviously with the hands, it was skin to skin.
correct.
Okay.
I think
All
that
right.
was, I think that came from the record. I don't know if I can't cite to where, but I think that was pretty clear to the jury.
Mr. Joseph, sorry to interrupt. I want to go back to the circumstances because you're talking about the physical circumstances of their placement in the room, et cetera. And in TAW, they talk also about the circumstances of them being a stranger, walking up to people on a bench. They talk more than just the physical circumstances of the touch.
But no, they did mention that he was a stranger. That is correct. So, I mean, how far do you go in the circumstances? I don't know where the line is. I mean, I know that you can definitely look at the physical circumstances, and that's what I read it. But you are correct. They did mention he's a stranger. Could you then take that to also include the instructor, student, instructor, inmate? Maybe, sure. I don't know where that line is. I think that's an interesting question, one which I don't know that TAW necessarily answers.
I'm proud. Atchison usually has the interesting questions, so.
Well, I'll give you this one, but I mean, frankly, the inmate versus instructor. I mean, if you're going to consider that, then you also consider student teacher, shoulder to shoulder, working together. You know, I don't know.
Aren't those the kinds of decisions that jurors make? I mean, the jury decides whether.
I mean, that's they decided in TAW too, and as the court pointed out in TAW, you know, that's fine. But you still have to go back and look at the actual nature of the touch and decide whether or not that was sufficient. But no, you're right, Judge. The jury decided. They decided in TAW too, and the court must then implement its duty to review to see if the evidence was sufficient. And I just don't think the leg touch, the clothed, as Judge Atchison points out, the clothed hand on a leg in and of itself is lewd. I mean, look at the definition of lewd. Sexually unchaste, suggested of tending to moral looseness, inciting to sexual desire or imagination, indecent, obscene, or salacious. I mean, you know, this is kind of like a hand on the shoulder. You know, I've had the creepy neck rub before. I mean, it's not, you know, the shoulder rub. I mean, it's uncomfortable, it's weird, it's awkward, but it's not necessarily. I don't think if somebody comes up and behind me and puts their hands on my shoulders and squeezes a couple times, that's, you know, lewd. It's weird sometimes, and I'm not a touchy guy, but some people are touchy, and all of their acts are not lewd.
You would agree that the testimony from some of the other putative victims in this case did constitute lewd and lascivious, but for whatever reason, I mean, the jury acquitted Coe of those charges.
But no, I agree. Absolutely. I mean, there was breast touching. There was all sorts of allegations made that the jury did not apparently find true beyond a reasonable doubt. And I think for good cause. The only one that they convicted on was where there were these outside indications of intent, this Christmas card and the such.
That was one of the things I was wondering. I mean, I haven't read the entire trial transcript. It seemed to me, and correct me if I'm mistaken, that apart from this victim, the other allegations were all essentially he said, she said, without external corroboration.
Multiple she saids. I mean, yeah, they were, yes, there were external corroboration.
Coe basically said none of this ever happened. I mean, it was his version. But
right, the only document that was produced was the Christmas card and the picture, and that related to this particular incident. But this particular incident was the least significant in terms of, you know, touching of he'd brush my hand while instructing me and put his hand on my knee. Least offensive in terms of the allegations of contact, but the only thing where there was a physical document to corroborate something. So I think your summary is correct, Judge.
And you want us to find that the touching that took place here, basically regardless of the circumstances, as Judge Hurst mentioned, that this is an inmate who would not be expected to be touched anywhere at all by a person in authority at the jail. You want us to decide as a matter of law that this touching did not meet the statutory criteria.
I do. I think you're compelled to under TAW. I mean, the touching in TAW was pretty weird and much more significant than the touching here. And I don't think you want to criminalize the, even if it's a student teacher or an inmate, what is somewhat common to have a teacher come up and put hands on shoulder or, rub the back. I mean, if you're going to outlaw all touching, even creepy touching, even awkward touching, I think that's a bridge too far. The sufficiency of the evidence just isn't there.
Mr. Joseph, back to the statute real quick.
Yes.
So your argument is clear that consensual modifies sodomy and lewd touching. And so then is your argument that non-consensual sodomy and non-consensual lewd touching would come under a different statute?
Yeah, and I think, well, to the extent that there's any overlap, absolutely, yeah.
Okay.
And I really don't think there's much overlap at all, because remember, in this statute, the defendant or the victim has to be 16 years or older. And think
Right.
about why that is, because only at age 16 can you consent. Can't consent below that. And all the other statutes, if there's no consent, absolutely. They're always more severe in offense, except for this unusual circumstance, it would be a Class A misdemeanor.
Misdemeanor battery.
I don't think the legislature thought about that. I mean, same thing with that electronic solicitation versus in-person solicitation. Weird, right? Maybe the legislature should fix that too. There's lots of weird things in the law where the legislature haven't thought about it. Courts don't fix it, legislatures do.
Well, the intent of this is clearly about power differentiation.
Correct. And so even when somebody says yes, it should
Right.
still be a crime. Even when they consent, it should still be a crime. And that was the whole point. And that, that's the example in the legislative history. There was a situation where somebody did say yes, or at least there was enough indication that they consented that they couldn't proceed under the non-consensual statutes. So they created this to still make it unlawful, even though the person says yes or seemingly consents, even though maybe they don't want to go along with it, they say yes. So we're outlawing consensual contact. Now, there are good policy arguments to get rid of the word consent, to say any kind of contact should be unlawful. But again, that's for the legislature, not for the courts. And my final comment is kind of a broad-based. The news reported on this case, and the comment, the ending or headline, I should say, was "Judge closes loophole in law." And I mean, even the reporter sees this. That's not what courts do. We don't close loopholes. We don't change laws. We implement them, even if we disagree with them. We implement them as they are on the books. And if somebody's going to close a loophole or change severity levels, it needs to be the legislature. And that's what these arguments should be going to, is to the legislature, not to the court. Thank you.
Thank you. Mr. Obermeyer?
Thank you. May it please the court, this state appears by Stephen Obermeyer. If I could pick up with issue 2 and then proceed in reverse order, since we were just talking about sufficiency of evidence. And in preparation for this argument, I listened to the oral arguments in State versus Taw, which was a case where really there's not much evidence as far as why the man was touching these 3 and 4-year-olds at the park. He basically, in his confession, explained what he was thinking at the time. And at oral arguments, the court was likening Mr. Taw's situation to a George Orwell book, 1984, and convicting somebody for mind think. And in fact, in the opinion, the Taw court says a defendant's mental state should not be used to define or determine whether a touching is lewd. This case is far different from that, and that's why I filed the 609 letter setting out the State versus Ketron, which says you have to look at all the circumstances, and it cites Rutherford and other cases in saying that, but you have to look at all the circumstances. The power differential, why does he have to reach under the table in the first place? This is not a hands on a shoulder situation that he was convicted of. I don't think my shoulder is an erogenous zone that I would want to try and initiate sexual contact with somebody. And as far as this victim, RH, she was the one who actually reported it she was the one who had corroborating evidence that in addition to the touching, he asked me what I was going to get him for Christmas, and I thought about it, and I gave him a Christmas card, which is States Exhibits 23 and 24. And on the front of the card, it says, when I was a kid, one of the best things about Christmas was choosing which present I'd take to bed with me. Open the card, now it's you. And she says, I don't have much to give except maybe this, and draws a big heart. She didn't just think of doing this on her own. She did this because she was there every day, was touched every day. There was a pattern of touching that extends over time, which the Ketron case talks about. The places on the body touched, the inner leg above the knee, the nature of the touching, there was no legitimate pat on the shoulder reason for it. The defendant's consciousness of guilt. He takes the Christmas card home with him, holds on to it for about a month instead of reporting it to the prison authorities, and writes, I am keeping it for now to find out where this is going. So he wants to see what's going on with this relationship. He's talking with RH about when she gets out of prison, the things they can do together. Mr. Obermeyer? Yes.
I understand the card and its implications. Can you explain to me how the card is not, us considering the card is not equivalent to legislating mind think?
Well, she wrote the card based on things that Dr. Coe said to her and did to her, and asked, what are you getting me for Christmas? So I think it's an outward sign of what he wanted her RH to give him for Christmas, and nothing.
Do you think the card adds to the contact being lewd?
Yes, I think it does explain being lewd, because we have a instructor-student situation. There's a lot of testimony about undue familiarity and how they're not supposed to talk about their family lives, or the interview questions, how many baby mamas do you have, or boyfriends or girlfriends? What does that have to do with making dentures?
And so then how is that distinguishable from TA, where the court tells us that I apologize, that we are not supposed to consider the mental state? How is that different?
Because TA was just thinking all those things. Dr. Coe stated all those things and did all those things to the inmates. And I think that's the difference, that he wasn't convicted for what was in his mind, just silently what he was thinking. It was his outward actions. It was his statements that can be, in looking at all the circumstances, that can be considered, including that he took a picture of her, or he took one of her pictures and had it blown up and said, I have a big picture of you on my nightstand. Interesting that it's in his bedroom, isn't it? So he wasn't just thinking that, he said that to RH. And she, writes this card. The touching had been followed by her offering her heart and taking him to bed with her. So I think without resolving evidentiary conflicts or reweighing the evidence, that a rational fact finder could fairly conclude that he was guilty of unlawful sexual relations.
Mr. Obermeyer,
yes.
Would you agree that there could be touching that has a sexual innuendo or connotation aspect to it that would not be lewd and lascivious? I mean, that there are degrees here, and you could have something that would be sexual without being lewd and lascivious.
Yes. In fact, in the Stout case, I think the issue is whether just the mere French kiss is enough to be lewd and lascivious. And I think the court said you have to look at it's not a bright line rule. You have to look at all the circumstances.
Well, I understand that. What about this circumstance makes the touching just above the knee lewd and lascivious as opposed to merely sexual?
Well, it's a sexual touching,
We're agreeing on that.
Okay, we agree on
How
that.
does it get to be lewd and lascivious?
Because you have this. It's in a manner which tends to undermine the morals of a reasonable person in that situation, and to the extent that she's sending him Christmas cards and writing seductive notes on that. In a prison setting with a power differential between an instructor and an inmate who, feels that they want this job because it pays more than any other prison job, and all of those other surrounding circumstances, I think that would rise to the level of a lewd contact. If I could go on to issue number one, then, and the court has the briefing, we have the grammatical argument that addresses Tolliver, where we look at the context of the phrase and the adjective lewd. Lewd is an adjective, and in the 609 letter, I cited a case where stating fondling or touching is not enough. It's vague. So in response to fondling or touching, either in Wells or in the Conley case, they added the adjective lewd to distinguish that. And so here we have lewd, touching, or fondlings. And in addition to that, as far as the context, Judge Rios, and in her memorandum decision is in the appendix in the blue brief, set out that you had subsection C is some other indication of that. And because it does not, it ties consensual to sexual intercourse.
Mr. Obermeyer,
Yes.
do you think it's possible to have two adjectives modifying lewd? Can you have modifying touching? Can you have consensual lewd touching? Do you think that exists?
I think the nature, a lewd touching, how could she have prevented that from happening? I mean, on a consensual intercourse, there's a penetration of an opening or an attempt to that. But how do you stop somebody from groping you or coming up from behind you and touching you? So
your argument's that you can stop intercourse, but you can't stop touching?
Has the crime occurred when the touching has already happened? I mean, it's already happened. So
if you're strong enough, you could stop someone from penetrating you.
You mean for rape? I mean,
right.
And so rape, and why a non-consensual sexual intercourse also requires force or fear to make that rape. We're here, so that would be a separate crime. In this case, I think once there's the lewd touching, lewd fondling or touching, the crime's committed.
So I'm querying if you are arguing that there can be no, you legally can't consensually lewd touch. I'm trying to figure out if that's your argument. Is your argument that lewd touching necessarily must be non-consensual?
I think it does not make sense to have a consensual lewd touching when you're looking at the definition of lewd. And do we carry the adjectives now? So is sodomy non-consensual lewd sodomy? Because we got two other adjectives in this phrase. So how does that work? So in this case, the consent, how can you have a consensual lewd fondling or touching that tends to undermine the morals of our age, which is so clearly offensive as to outrage the moral senses of a reasonable person?
So if she engaged in French kissing in this situation,
Okay.
as in the prior case, consensually French kissed, would that fall under your definition of this statute?
Well, I think Judge Rios, in her opinion, said that consensual wasn't really an issue in that case. It was a fact of the case. So the lewd touching can be consensual because the victim initiated the French kissing or not.
So your argument is that the statute, we should read it to be consensual or non-consensual lewd touching.
Right, either one. I think the legislative testimony was to prevent sexual contact between inmates and the prisoners and the guards that supervise them, or the people that supervise them. I don't think there was a lobby of employees for non-consensual lewd contact that testified at the legislative hearings, giving us an exception so we could, continue.
So I just want to clarify that under your argument, we would read this to include any consensual or non-consensual lewd touching, and those would be criminalized at the same level. The non-consensual lewd touching would have the same criminal effect as the consensual lewd touching.
I think that's the interpretation.
And the non-consensual sodomy would have the same criminal effect as consensual intercourse.
Okay, the non-consensual sodomy, if you have the additional elements of, it could be an aggravated criminal sodomy.
No, under your reading of this, it would be consensual sodomy and non-consensual sodomy, and consensual sex and consensual lewd touching and non-consensual lewd touching. So that would mean that non-consensual sodomy, same penalty as consensual French kissing, same level.
I think you have a more specific statute in that situation, which is the KSA 215504.
No, I know you could charge something else. You could have charged something else in this case. What I'm saying is, if you want us to read this as it says consensual and non-consensual, then it's not just lewd touching, we also have sodomy.
Well, and that's not the case before us, but so I really haven't, it might have been initially been non-consensual sodomy, but I don't know if it should be non-consensual lewd sodomy under their interpretation of the statute, because we're just bringing over every adjective that's in front of.
No, they're just talking about the leading adjective in that argument.
Okay.
So then is it ambiguous? Because you're saying you're not sure if consensual and non-consensual sodomy should be at the same level, then is the statute ambiguous?
I think Judge Rios thought initially it was, but when the amendment was made in 2012 and consensual was taken out in front of sodomy or lewd fondling or touching, that changed it. So I guess if it's non-consensual sodomy without force or fear, then it could be unlawful sexual relations.
The same as consensual French kissing.
The same as consensual French kissing. Let's see. So I think I've talked about the statute. The Johnson and Edwards cases talk about what the intent of that statute is. There is discussion that we want to prohibit this in legislative history. Just really briefly on the pattern instructions, Judge Stephen Hill has been on the PIC committee for a long time. His annual updates basically say, these are the new cases that have come out and the new statutes that have come out. I don't think the PIC committee takes a global look at all the criminal codes and say, hey, do we need to change anything? So I disagree that it's well settled. The issue has not come up until this case. And then lastly, I also briefed what is consensual what would be the definition of consensual in a prison setting under this statute? And I think it would be a grudging acquiescence is what happened to the victims in this case. And that you really can't stop a groping or inappropriate touching or fondling like there was in this case. In addition, this is a jury instruction issue. And if the court disagrees as far as the definition of consent, and there wasn't enough evidence of that, then the remedy would be that there should be another trial with the jury properly instructed on the elements. I see that I'm out of time. I don't know if the court.
I'm sorry, I was reading.
Okay.
I told you I'm bad at this. I'm terrible at this.
Well, I just think this case is a poster child for the enactment of the unlawful sexual relations statute and why it's in existence. So, and I would ask you to affirm the defendant's convictions. Thank you.
Thank you. Mr. Joseph. Now that
I
I've
will just.
shamed.
Thank you. I'm just going to touch one last time on the consent issue. There are orders, the rules for statutory construction go in a certain order. The first of which, you look at the plain language. Consent would modify all of them. The extent that the state has raised issues that are sufficient to create ambiguity, certainly not strong enough to say consent doesn't modify all of them. But if it creates ambiguity, then we go to the legislative history. Beginning on page 4 of our reply brief, it is very well, I won't go over it. The history is pretty darn clear, including subsection C of what was intended. Ambiguity, if it exists, is resolved by legislative history, and the history is very solid that the intent was to address consensual relations between people in position of power and prohibit those and make those criminal as well. I think it is significant that the Judicial Council has had this pattern instruction for such a long time that the legislature has amended it 8 times since then, the statute itself 8 times since then, with this pattern instruction requiring consent for each 3 of them, and has never done anything to fix that, to signal to the Judicial Council or the courts that, hey, that's not what we mean, because that is what they mean. It's consensual. It is the bucket of crimes for prohibiting consensual conduct that shouldn't happen because of differentials in positions of power. I think it's clear in the plain language, and it's clear from the legislative history, and that's all the further the court needs to go. The district court struck an element, instructed the jury that there was no element of consent, and that's enough for reversal. In fact, the state argued that there was no consent and framed it as much. So there really is no evidence to go back to trial on. I guess they could try to flip it and argue all of a sudden completely opposite, but there is no evidence that it was consensual. It was all the evidence was it was non-consensual. So I think the case ends simply on that.
So what's your response? I mean, you're right. The legislature, I think, wanted to get to the differential of power between an inmate and a guard or teacher or whoever. So how does that differential of power feed into whether something is lewd?
So interesting question. So going back to Ta and Judge Hurst's very interesting question.
Definitely, he's touching 2 little girls on their hands and face and everywhere. And he has a lewd motive. He agrees to that. And the court says, it's creepy behavior, but it's not lewd behavior. Right.
I think this is creepy, but not lewd. I think the shoulder touches. I mean, I've had instructors reach over and tap me on the leg, touch me on the knee. I mean, it's
but this was under a table, wasn't it? I mean, this wasn't.
It's in it. If you look at the exhibits, it's a wide open space. I mean, there's a bunch of people on either side. I mean, it's not like it's a particularly secretive thing. It's just that the table hangs over because they're working. We're not in person, but you can see kind of working over a table and just kind of reaching over and tapping on the leg. It's not. I mean, if you look at the exhibits, it's not like this is some secretive thing. It's a giant wide open area. It's not a creepy secret way to touch somebody. And that's That's why the state kept saying everybody knew, everybody saw he was creepy, and the jury did not accept that with respect to the other victim's testimony. But the point is, the touch itself is relatively minor. I mean, it's a touch on the leg, and it's not itself not much. Now, to Judge Hurst's question and Judge Arnold Berger's most recent question, what do we do about the relationship itself? You know, the nature of the power differential. Is that a circumstance to be considered? And, you know, I've thought about that since Judge Hurst asked it. It is true that in TAW they talk about the stranger and not just the physical circumstances. And so in that respect, I guess you could, but the statute itself is criminalizing and assumes that, right? It's the statute itself already takes that into consideration, saying there is a power differential. So you're kind of double counting, I guess, if you will, because every one of these is necessarily going to have that power differential, right? So if we're going to use the power differential to determine what's lewd, every one of these is going to be lewd, right? Because to be charged under the statute, there has to be that power differential. There has to be that special relationship. So
And at
to me,
a
it seems a little
minimum,
unfair.
this activity would certainly be a battery. Simple
Yeah, I mean,
battery.
they
Under
could have
any
charged a
definition.
misdemeanor sexual battery. Absolutely. They
Not
again,
even
they took the
sexual
risk.
It could be just, I mean,
Could be a battery, could be a
right.
misdemeanor
I mean,
sexual.
if sexual battery, you're back into the lewd area, but
Well, no, you're not into the lewd. Lewd is different. Misdemeanor sexual battery requires with intent to satisfy the sexual interest or desire of the defendant, which is a little different than lewd.
right.
Lewd is, unchaste. It's got that really powerful definition. It's got to be beyond just sexual, as Judge Atchison was mentioning. Lewd is stronger than just sexual. So, they could have done just battery. They could have done sexual battery. I think they had it, if you assume the light, I would have no case if he had been convicted of sexual battery on appeal for sufficiency of the evidence, assuming the evidence of the light most favorable to the state. I'd been cooked. But they chose to do lewd touching under this statute that's intended to apply for consensual relationships. So where I was headed earlier was Judge Hurst's question. I don't think you consider the power differential because every case will have that power differential. That's a kind of a double count. To be charged, you're going to have that power differential. So I don't think, while Tom mentioned stranger, I don't think you can double count it that way. That just seems unfair because that would make almost every touch lewd because of the power differential.
Thank you. That's helpful. Any other questions of Mr. Joseph? Okay, thank you all very much. We appreciate your arguments today and your well-written briefs, which we're very appreciative for. You've raised some very interesting questions today on a very important case. So we will take this under advisement and get out a decision as quickly as possible.
Thank you.
Thank you.